Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about Indigenous people in custody. Cases that should have gone to the Supreme Court of Canada, but didn't. Justin Girma was an Indigenous person in custody. During his time in custody, he was found to be in possession of a controlled substance. As a result of this, he was placed into segregation. A change was made to his security classification, which meant that he would be transferred to a higher security institution. This request to change his security classification was approved, and Mr. Girma wanted to appeal the decision in order to keep himself from being transferred to the higher security institution. He filed a claim in the criminal courts for something known as a writ of habeas corpus, essentially requiring the court to review the decision to reclassify his security transfer. As a result of filing this application, a judge reviewed the application, determined that it was essentially civil in nature, and told him that he had to file it in civil court instead. By the time Mr. Girma got around to filing in civil court, the time limit that he had to file the application, which was only 10 days, had already elapsed. This meant that Mr. Girma could no longer bring the application and was stuck essentially dealing with the security classification that he'd been given. And this case obviously raises important issues about the fairness and access to justice of rules like this, particularly when dealing with Indigenous offenders. The Criminal Code of Canada recognizes that Indigenous offenders deserve to be treated with special recognition for the historical injustices and systemic discrimination that they continue to suffer in Canada. And this case is another example of that, where Mr. Girma was put in a position where he had to bring an application in a very short period of time, brought the application in the wrong forum, and then was prevented from being able to bring it in the correct form. It makes no sense that the application could not just be converted to an application in the correct form to allow him to continue with his application, particularly bearing in mind the overrepresentation of Indigenous offenders in the criminal justice system and in particular in jails in Canada. In addition to this case, there's also the important issues that were raised in Mr. Girma's case about the inherent unfairness of time limits of only 10 days to bring these types of applications when people are in segregation and have much less access to the resources needed to bring these applications, or are affected by the systemic discrimination that makes it more difficult to access those services in the first place. Imposing these limits and imposing a hard deadline on bringing these types of applications has a necessarily detrimental effect to people who are trying to exercise their legal rights in custody, and specifically a necessarily detrimental effect on Indigenous people who are trying to exercise their legal rights while in custody. It seems absolutely absurd, as well, that a writ of habeas corpus cannot be brought in a criminal proceeding when the whole reason that Mr. Girma was in the situation that he was in had to do with criminal conduct and not civil conduct, the possession of a controlled substance and whatever it was that landed him in jail in the first place. And so all of these things made sense as far as somebody looking at the justice system from the position that Mr. Girma was in without the ability to access legal services or the internet because of the fact that he was in segregation. So how can it be fair to impose these timelines on him? The Supreme Court of Canada had the chance here to right what was clearly a wrong, to correct an unfairness, and to undo what appears on its face to be an injustice. And unfortunately, they didn't do the right thing in this case by hearing this case and by addressing circumstances, by creating an inherent ability to allow for extensions or to allow for applications that are filed in the wrong form to simply be converted into the correct form without the need to refile and to be treated as though they were originally filed in the correct form. This, to me, seems to be an appropriate and just result that doesn't result in any significant prejudice to the Crown or to a correctional institution, and the Supreme Court of Canada missed the boat here. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.